Welcome to Law for Life with Georgia.
Welcome to where Attorney Georgia Konstantakis brings nearly 3 decades of Wisconsin legal experience to help her community stay informed, protected, and prepared for whatever life brings. I'm Lisa Mosby, your host, and today Georgia is diving in to discuss OWI charges in Wisconsin and what's really at stake here. Welcome back, Georgia.
Oh, thanks for having me, Lisa.
Georgia, is an OWI in Wisconsin actually 2 separate cases, one with the court and one with the DMV?
It is. It is. A lot of people don't realize that. We have the OWI that the court handles, and then the Department of Motor Vehicles does a license suspension. So if you don't contest it within 10 days, what happens is your license gets suspended. So there is a window of opportunity, and it's 10 business days, whereby you would have to challenge the automatic license suspension. So it's technically not 2 cases, it's really 1 case, but the Department of Transportation, or DMV, will suspend your license for the period that, depending on which one it is, because we have multiple OWIs. We have a first, we have a second, we have a third, and so on. And unfortunately, that will happen. There is an automatic suspension period of 6 months.
Georgia, let's define OWI because you said there's multiples. Let's explain what that is so the audience is clear.
Yeah, so an OWI first is believe it or not, we're one of the few states where an OWI first is not criminal. It is a civil ordinance violation type of a case. There is no jail time whatsoever, which is good, but it also is bad because essentially it's a free pass. And then you get into different levels. So you have OWI first, then you go into OWI second, which tends to it's considered criminal and it's a misdemeanor. And then the levels go higher and higher. And then you have a third, then you have a fourth. Once you get into the fourth range, you're talking felony. So, but those are the different levels. And in Wisconsin, an OWI first would tend to be, and of course, this is very different for other states, but in our state, depending on where you get stopped. So if you are stopped on a highway, that would be in a circuit court. If you're stopped on a side street, it would be in the city in which you were stopped. So for example, I live here in the city or I work here in the city of Greenfield. If there is an individual that is driving on the roadway that's not a highway, and say it's a side street, that individual would be required to go to the Greenfield Municipal Court, not the Milwaukee Circuit Court. So, and in that instance, there are no criminal penalties. It's all dealt with on a civil fashion. So with OWI first, you're looking at about a minimum of 6-month license suspension. It can go up to 8. And it's very expensive to get an OWI. One of the things that will happen is you'll need to get SR22 insurance. So SR22 insurance is a special insurance to ensure that if you are driving on the roadway for the next 6 months, you're going to have this insurance. And if that is your suspension period is 6 months, because that's the absolute minimum is 6 months, then in that time frame, you are able to drive, but you drive on an occupational license. So the occupational license is the ability to go from work to your home, the ability to drive to, for example, Target, or if you need to go to Sam's Club, or if you wanted to go to church. There are certain things that you'll need to tick on the occupational license application in order to be able to do those things. And if you are driving outside of that window of time, then you will be charged criminally. with violating the restriction. So it's critical that when you do get an OWI first and you get an occupational license, you drive within the time frame that the license on the back of the license tells you to.
And then, Georgia, you often represent people who have never been in trouble before. What is the first thing that you do to ensure a single OWI arrest doesn't lead to a permanent criminal label?
So a first is not going to be criminal. The only time it would bump up to criminal would be if there was a handgun in the car while the person was drunk, or if they were driving with a minor. Those are big no-nos. Those would lead to criminal penalties, criminal label. But in any event, it is a civil ordinance violation. It's not criminal. It does impact though your record because it is counted forever and it could impact your job. It can impact your reputation. It's good to be transparent, but at the same time, we want to make sure that we're not labeled to the point where, you can't go to work or you can't be in a car with a coworker without having to blow into a breathalyzer. That's certainly something that what we like to do is try to avoid the breathalyzer as much as possible if we could, because it's quite the IID device is just very invasive. Once you get that in your car, you have to blow in order to start the car. In the middle of driving, you'll have to blow into the device, and it obviously has a reading ensuring that you're not driving drunk or have any alcohol in your system. But what we do when we take an OWI first case, we analyze the stop. We determine that, in fact, the stop was valid. We look at the constitutional issues that may have been violated. I've been very successful in the past in getting people off of an OWI first because the stop was not valid. So that's something that we look at. Another thing now that many police stations are doing is they've got body cams, they have dash cams, they've got reports, which dictate there's a 3-hour window in which once a person gets stopped, you have to breathalyze them. Otherwise, you can play around with we call it the bell curve. When you get, for example, a blood alcohol level over a 0.15, that's when we try to argue that the IID device should not be installed in the vehicle. We'll hire an expert to say at the time of the stop, the blood level was not at a 0.15, but it escalated to that, at the time that they actually took him to the station and got him tested. So, and typically breathalyzers they're not admissible into evidence. They call it the PBT test. That is not admitted into evidence. But when you go into a station and actually do the test, that is the test that counts.
Yeah, in Wisconsin, if you're pulled over, is it legally better to refuse the breathalyzer, or does that refusal carry its own set of severe penalties?
Yeah, a refusal, you don't want to get a refusal. Those are I'll tell you, I had to fight a lot of these cases back in the day. I'm not as much doing OWI as I used to because now I'm the judge in Franklin. So I am someone who hears these cases, but the breathalyzer and failing to refuse, we have what's known as the implied consent in this state. So implied consent means if you are on a roadway in the state of Wisconsin, you have automatically implied that you will in fact take that breathalyzer test. You will do it if the officer asks you to do it. So refusing it could put you in a deeper hole because then there's an automatic IID device that you have to install in the vehicle for 1 year. And quite honestly, I've talked about the IID device in the previous question. It is an invasive device. You definitely don't want that. So again, refusing, automatically your license gets revoked, automatically mandatory ignition interlock device, and there are separate penalties, and we're talking bigger penalties. So There's higher fines that you have to pay. And the having to install that device in your car for a year, ugh, that's just invasive. Can you imagine being a soccer mom and you've got a boatload of kids in the car, and every time you start the car or in the middle of driving the car, you have to blow into this test? I mean, it's a nightmare. It's a nightmare. So, or say you're driving with a coworker and you have to explain to the coworker that you've got this ignition interlock device in your car and you got to blow in it in order for it to start the engine. And if you don't blow on into it in time, all the lights go off in the car. So it's quite embarrassing. It's definitely an invasive device, but it does its job because people don't reoffend typically. The reoffenders tend to be those who have more psychological issues, whether it be bipolar, schizophrenia, severe anxiety, depression, things that they try to diagnose on their self with using alcohol or drugs, for example. So I often say, when you do it once, shame on me, do it twice, shame on you, so it does apply here. So people do learn their lessons. They get caught with a first and they don't do it again, typically. Typically.
I'm thinking of some myths. There's kind of some myths amongst certain people that the breath testing machines are not infallible, and there might be hidden ways for these devices to produce a false positive. I want you to speak. Any truth to that? Is it just a myth?
If you don't calibrate this test, that's the first and foremost. You got to make sure you've maintained and calibrated the test. That's something that's done by the police at the police station. If that test is not calibrated and you've gotten evidence to show that it hasn't been, there could be a way to get out of this OWI. That is a defense. So, improperly administering the test. You got also medical conditions. Some people suffer from acid reflux. So that could screw up the test and make the test higher than what it would be. Again, there's all kinds of factors that could play a role. When we look at this bell curve, you go up and you go up to the top and then it starts to come down. So that is the bell curve that shows what your blood alcohol level is. 0.08 means now you're driving drunk. But there are instances where police officers use the totality of circumstances to say, I believe that this person, even though their blood alcohol level wasn't a 0.08, say it was a 0.07, I've seen scenarios where police officers have issued OWIs in those instances. And sometimes police officers make mistakes, unfortunately. So that's something that's used to the advantage of the defense attorneys. And one of those, if you're new to the industry and you don't know that you definitely need to make sure your machines are fully calibrated and ready to go, unfortunately it could be used against you, and it's data that you can dig into as a defense attorney and make it a weakness of the state.
Georgia, for a first-time offender, how does an OWI, I think it's called the OWI diversion program, how does that work in Wisconsin? And if an individual completes it, does that OWI get removed from their permanent record?
No. In the state of Wisconsin, an OWI first, you're either found guilty or not guilty. The diversion program does not apply where we are here in the Milwaukee County area. And I've seen people use it based on the individual's background, based on, finding some sort of defect in the equipment and then just saying, okay, we're going to take this OWI first and amend it to a reckless driving. Diversion programs, we don't have that. There is no diversion. It's based on, were you driving drunk? They look at the OWI. If you have a 0.08 or higher, or you have drugs in your system, that is considered, even though it's Operating while intoxicated is one, operating with a controlled substance is another. It is the same. It's an OWI, but it's an operating with a controlled substance. So if you have drugs in your system, that is another factor that's looked at. Now, these programs, these diversion programs, can be used in situations where you might make, a plan. They call it, it's a, a sobriety type of a plan and counseling and, taking classes and things of that nature. But in Wisconsin, OWI first, it's not criminal. It's a civil ordinance violation. It will continue to be on your record. You could do classes, you could do sobriety, you could do all of that stuff, but it's not going to make a difference. It will be on your record forever. It will not go away.
And then can a person be legally sober when they're behind the wheel, but over the limit by the time they get to the police station? You mentioned this bell curve. How do you use science to prove that timeline to a jury?
Yeah, so we hire experts. They're actual experts that analyze these bell curves and determine if, in fact, at the time of the stop, at the time that they were caught doing it, that it wasn't over the point oh 0.08. So we use experts and they provide testimony to argue that there is absolutely no way that this individual at the time of the stop was at a 0.08. They were below the 0.08. It's only after they were taken into the station and actually, breathalyzed and obviously at that point the number was higher. So in that instance, you can make those arguments, but you need to hire experts. It's extremely expensive. It'll take a long time, and sometimes you have to take these to trial. And if you do, in fact, take it to trial, you got to make sure that you have a credible expert and that they know what they're talking about when they're talking about the bell curve.
Here's where I want to wrap this up today. When someone is looking for a Wisconsin OWI attorney, why is it vital that they choose a lawyer who actually takes cases to trial rather than one who just processes guilty pleas?
Well, you have those attorneys that obviously are afraid to go to trial. They're afraid to, for whatever reason, they feel that the case doesn't have enough merit to take it to trial. But making sure that you have someone that's experienced that can file a motion to suppress, that can challenge the evidence, knows what they're reading. When they get the incident report from the city prosecutor or uh, say the district attorney's office, you got to make sure you're reading that report and understanding and knowing and being able to pick any loopholes that can be used to challenge it and take it to trial. So negotiating is one thing. Everybody can negotiate, but making sure that you know uh, you have used your motion to suppress uh, smartly is wonderful. So I had a case that I had done. This was quite some time ago, but the fact this in this case had some loopholes in it. The individual was stopped in their home, so the police officer followed them all the way into the driveway, and the person was inside their garage when they were stumbling out. So in that instance, we were able to file a motion to suppress the evidence because the police officer didn't have the authority to investigate while the person was in that home. So the case got reduced to a reckless driving. But in that instance, you had witnesses who saw this driver driving, obviously over the lines, crossing the lines, swerving, whatnot. And unfortunately, as a defense attorney, that's your biggest nightmare when you have witnesses that are ready to testify and go to court. So, um, and it's a crapshoot. Every case is different. So you got to just look at where you can and make determinations. Sometimes the stop isn't a good stop. They didn't have the authority to stop the person. Most seasoned police officers are going to put 1 to 3 different reasons why they stopped that person. It won't just be because your headlights were out. It's going to be 3 to 4 reasons why they stopped you. Crossing the center line, um, a headlight out, failure to display your license plate. There's reasons. So that shows that they had probable cause to stop that individual and thinking, this person's probably driving drunk. And so, again, having a seasoned attorney, somebody who can file motions, isn't afraid to file motions, and take it to trial if they need to, separates the negotiators from the trial attorneys.
Georgia, thanks so much for your guidance today. That's it for today's episode of Law for Life with Georgia. To learn more about Georgia and Konstantakis Law Offices, LLC, visit konstantakislaw.com. Thank you for listening, and be sure to subscribe, share, and leave a review if you found this episode helpful. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.